All right, everyone. I'll encourage you to wrap up those conversations and take a seat, and we'll get started. It's looking a little bit more sparse out there, but not even ethics can keep you around. My name's Zach Smith. I'm the staff attorney for the Colorado Water Trust. If you don't know the Water Trust, we're a nonprofit based in Denver, and we work statewide to restore stream flow to Colorado's rivers in need. And what that really means is we give rivers a seat in Colorado's water markets. I'll let Jamie introduce himself later when he comes up here. But first I wanted to commend the law school. Professor Cheever was a professor of mine when I was here and a mentor afterwards. And when I heard the news of his death, my first reaction was regret. And it was regret that other students wouldn't have the same opportunities that I did to learn from him. And so I was pleased to hear that the law school is doing something to honor him and keep his memory alive in future students. So this is the ethics panel, and Professor Romero suggested early on that we get uncomfortable. Now, having heard so many stories about what could be considered ethical lapses from California to Michigan, who is feeling uncomfortable or more than uncomfortable about what we heard today? Yeah, many of you in the room. I'm also uncomfortable because in thinking about my slides, after hearing these compelling stories, I'm thinking about one of my slides in the future that defines the word knowingly from an ethics perspective, and that is not compelling. But that is the ethics panel today, at least in part. So thanks for being here. Let's start off with a little public radio humor. Who here listens to Wait, Don't Tell Me on NPR? More than I would have thought. So you all know the Bluff the Listener game. Let's play a little game of Bluff the Lawyer real quick. The idea is the contestants, you all have to choose of these upcoming headlines on the board, which one is true and which did I just make up on the fly. Number one, do not pay adds 1,000 legal bots plus service for others to create their own. Number two, legal tech download, AI clerks and Chinese robots. And number three, using Avo legal services is unethical, New York bar says. Who thinks number one is real? Who thinks number two is real? I see a smattering of hands for two. Who thinks number three is real?
How many are real and how many aren't real?
That's a good question. I already broke a rule and lied to you from the beginning. They're all real. And we're going to tie this trend in the legal profession back to questions of access to justice as we go through this. We're going to talk about unbundled legal services and pro se persons in transactions and litigation, talking about how lawyers can talk to government persons, and then if we have time, touch on some conflict issues. So the state has thought a little bit, at least, about access to justice. It produced a report in 2004 that came to some findings that are applicable in this audience. That the Colorado Legal Services funding has been reduced by 10% from 2009 to 2013. That legal service providers in the state turn down 1 of every 2 eligible applicants for services because of inadequate staff and resources. That 50% of all civil litigants and 76% of domestic relation parties are pro se folks. And so there are a lot of pro se people in our court system and otherwise in this state. And that's not just in sort of more routine civil matters, but it is also found in our water court system here in Colorado. For those of you who don't know, we have courts of special jurisdiction here in Colorado that deal with water matters. And these figures come from Lindsay Radcliffe, who you've probably heard of many times today, and Josh Boissevain. They're working on an article entitled Self-Represented Parties in Colorado's Water Courts, and I stole this information from them. But our water court system here in Colorado is by water division. These are just large watersheds. So Division 2 is the Arkansas Basin. And the current docket has 15% of both opposers and applicants are pro se. Division 3 applicants, up to 30% have been pro se. And you can see on down the list, the highest that they've found so far was in Division 7. That's the southwestern part of the state. Up to 46% of applicants were pro se there. So these folks are out there in our water court system, and they may not have the adequate representation that they need.
Can I interrupt just a sec?
Yeah.
And this, as I understand it, Lindsay, correct me if I'm
Will you
wrong.
introduce yourself?
Oh, Jamie Sudler. I'm a lawyer, and I'm also a journalist now, but reporting about water issues. But as I understand these statistics, this does not include those who don't get into the system because they don't have a lawyer. And that, I think that, you know, that keeps, it's important to keep in mind that there are a lot of people who just don't go to court, don't have access to justice in water matters because they're scared. They're not going to go to court, fight our good friend here or other water lawyers in the room. Just pointed that out.
Thanks, Jamie. Will you tell for those of you who don't know, why I brought the expert along with me? Your background?
I'm the expert, yeah. I spent 24 years in the Office of Attorney Regulation of the Supreme Court of Colorado. In Colorado, we regulate lawyers underneath the Supreme Court as a function of the Supreme Court. In a lot of other states that you may be familiar with, the Bar Association does it, but not in Colorado. The Office of Attorney Regulation has 18 lawyers, I think, and that's a medium-sized attorney regulation office in the country. California is huge. California has so many lawyers. We have around 30,000 licensed lawyers, I think, in Colorado, and I don't know, I'm guessing California may have 200,000, 250,000. So it's a big part of the state judicial system. Attorney regulation.
Thank you. So the judiciary recognizes this to some degree. You can go on the Colorado Water Court website and find forms to fill out to make an application for a new water right or change a water right or oppose an application. But you know, it's one thing to sort of get your foot in the door in court. It's an entirely other thing to adequately represent yourself in that proceeding. And so these numbers of pro se parties have led to something that apparently is called the Uber effect, where you can turn any sort of problem into a tech app endeavor, I guess. And so this again comes from the headlines. This is a Florida case. An app called Ticked allows you to upload your parking tickets, and then that app contracts with an independent attorney to sort of help you reduce your fine, essentially. And the Florida Bar Association and now the Florida Supreme Court is looking into whether this app is practicing law or not, and whether they're in violation of various ethical rules that have to do with advertising and fee arrangements, that kind of thing. And so, you know, I poked around on their website today, or yesterday. So with the app, you can get all the benefits of a court challenge along with the convenience of paying your fine without the additional costs of hiring an attorney. And so TICT is fighting, there's actually this very interesting fight in Florida right now. TICT, the app, is fighting this series of law practices called the Ticket Clinic. And the Ticket Clinic is saying, these guys are practicing law, they have to be lawyers and regulated like lawyers. And the argument that TICT is making is, you guys are too expensive, this is an access to justice issue, we can get people, we can sort of not represent them, but get them lower fines by going through our app. And so you can see the tension in the legal system there of wanting to provide legal services to people, but there's already a sort of professional momentum to keep that in the legal sphere. And then if you sort of go down and look at the bottom of the website, this is not a law firm, it does not provide legal services. There are also water policy implications here in the state. For example, there was a bill that had passed and made it out of the General Assembly in 2014, and it would have allowed an irrigator on the western slope to quantify, make their system more efficient, quantify the amount of water that they saved through those efficiencies, and then transfer those efficiencies into the state's in-stream flow program so that saved water could be protected in the river. And Governor Hickenlooper vetoed that legislation. And the letter sort of goes on and on about the positives of the legislation, that the bill's goals are really important, that we ought to do everything that we can to encourage conservation. But because our water court system is set up as adversarial, and it is to a large degree self-policing, there was a concern that, well, lots of people might use this. It might be too good of an idea. And that is not a water trust opinion. That's just my opinion. That the burden, it would be too costly for everyone to protect their own water rights in these quantification proceedings. And so the sort of lack of access to the water court system has prevented certain bills from moving forward in the state. All right, so let's go to the kind of normal ethics. For the non-lawyers here, we do hypos and then we talk about rules, and it gets real confusing and sometimes boring. But we're going to do it because that's what we do. So hypo 1, a developer buys a piece of rural land with irrigation water rights. The developer wants to build a pond that would sit in between several future home sites. The developer hires an attorney to provide legal services in connection with building and filling the pond. Attorney decides developer needs to file a change of water right application to change a portion of the irrigation water right storage, a portion of the irrigation water right to storage at the new pond. Developer directs attorney to file that case. Downstream irrigator sees the notice of the case published in the local newspaper. Downstream irrigator decides to file a statement of opposition pro se. As part of settlement, downstream irrigator decides to lease a portion of her water rights to developer. Attorney for the developer drafts lease and sends the draft to the downstream irrigator. So we're going to play a game called Think, Pair, Share. Find a neighbor, spend 30 seconds thinking about what ethics issues might be involved in this. Go. 5 seconds. Okay, time's up. Who wants to, raise a potential legal ethics issue, or if you get that tickling in the back of your neck when you read this, and it may implicate some rule in Colorado's rules of professional conduct, what comes to mind?
You all know the rules by heart. I know it, those of you who are lawyers. For those of you who aren't lawyers, you have to understand that lawyers are regulated pretty deeply. There's a large set of rules that they have to follow, and the one that Zach is bringing up here is one that is important for lawyers to know about when you're dealing with a pro se party.
There's some hints in there, in the back of the room.
The attorney needs to advise the downstream irrigator that they need an attorney to also be present or look over the contract or be advised of their rights according to this.
Right, so there's an issue that one party is represented by an attorney, but the other is not. And that's the answer that we were looking for. Thank you.
Excuse me.
Yes.
In the acequia, we would not have, I looked at it differently. In the acequia, if somebody wants to do that, we would have to notify all the parciantes on that ditch, not just that lady. Even though she's complaining, everyone gets advised of it, and that way they have a chance to give an input.
And is that
more than likely, we'd say no.
And how do you all get the word out then through the community? Just pick
One of those old-fashioned phones. The old-fashioned kind.
the phone tree.
The phone tree,
Perfect.
yeah. And then they panic and the rumor flies right through the community, and next thing you know, they're falling over each other to come to the meeting. Yeah.
It's a good practice point for everyone. Thank you very much for sharing. And I encourage the other panelists, sort of as we're talking about this, these issues, if this kind of tickles something for you, speak up and let us know.
Well, let me give you a real-world example of this problem that came up when I was regulating lawyers. A lawyer was representing, it wasn't a water case. For your information, I was in the office for 24 years. I bet 3, 4, 5 cases that I handled or was involved in are out of probably 1,500 to 2,500 involved water law. And so that must give you water lawyers some comfort. But if you do something on the side, I'm going to tell you this story where this lawyer was representing a husband in a custody case. And there were very significant issues about the mental health of the wife. They were trying to get child custody for the husband. So the lawyer called up the mental health expert for the wife and did not make it clear that she was representing the husband. The mental health expert assumed she was representing the wife and proceeded to give all of this confidential information to the lawyer. And the lawyer should have made it clear at the outset of the phone call, I represent husband, but she did not. And she got disciplined for that, not severely. Severely meaning her license was suspended, but that didn't happen to her. She got basically a public reprimand for that. And the point is that if you know there's a misunderstanding by the pro se party, you've got to correct it. You have to make that clear.
Thanks, Jamie.
Well, let me
yeah.
ask you.
Yeah, my former boss.
Jamie, isn't it incumbent on the attorney to advise the person that gets the contract that they ought to get legal help?
Absolutely.
That they ought to get legal help to go over the terms of the contract, that he or she can't provide them that advice or interpret the proposed contract for them.
Absolutely. In this phone call that I was referencing, it wasn't an opposing party. It was just a potential witness. But the rule still applies. And I think you're going to go into that, Zach.
Yeah. Okay, we have these pro se applicants or opposers all the time in water court.
Yes.
So, lots of times the farmers on the ditch are pretty sophisticated, or the ditch company has a bylaw that looks into these things, right? Mm-hmm. So there's some way to get informed, but it still is a problem that a person isn't represented.
Absolutely.
Some people just don't want to hire an attorney.
and they can't afford it. I mean, I
Yeah.
think that the why of the problem is it's very important. Why aren't people represented? And a lot of the information is that lawyers have priced themselves way too high to represent people. Why have we priced ourselves so high? Because new lawyers have student loans they got to pay off. They got to get a job and pay off the student loans, and that means they have to increase their rates. But there have been other proposals to deal with this unrepresented cohort of people. One was to do limited licensed legal technicians in the state who could, sort of like paralegals who would pass a test, who could do certain things for people. The water court, I don't know if they would be able to do that. But the Bar Association of Colorado was dead set against that proposal. And it sort of lost the political will to handle that cohort through less than lawyers, limited licensed legal technicians.
Can I ask you a question on that? I really don't know that much about water court, but we have pro se litigant coordinators. We hand out their cards at the courts. They call them up whether they have a civil, over 15,000, or whether they have a divorce coming up. They call these litigant coordinators and they set up appointments and they go through all the forms of paperwork. Why doesn't water court have that? I mean, it's the state of Colorado.
I don't know.
It's provided by judicial. They're paid by judicial.
I do not know the answer to that. I'm looking at Justice Hobbs to see if he knows, but they're called Sherlocks, right? I believe they're called
Well,
Sherlocks.
I don't know it. We just call them pro se litigant coordinators, and we have their cards and we just hand them out.
Well, lots of times the referee or the division engineer help those who aren't represented, at least, the referee get the forms filled out. The clerk, the water clerk can help with that. And the referee is a more informal process, and the division engineer gets a chance to comment about what the implications are of the application, including injury applications. So there is some sort of system built in for this, but it still doesn't substitute when you get into a full-scale knockdown, drag-out water rights battle for having an attorney. So, but I know there's some smart students here looking into how this might be ameliorated. I'd love to hear from them at some point. I'm looking at two of them.
All right, well, we're sort of beating around the bush of Rule 4.3, and I'll just read portions of it. In dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. When the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. And so that may go to the hypo that we heard already.
Yeah, exactly. If you know the person doesn't understand your role on the other side and you don't represent them, well, sometimes your clients don't understand that you represent them. But on the other side, if you know they don't understand your role, the lawyer's duty is to make it clear.
The lawyer shall not give legal advice to an unrepresented person other than advice to secure counsel if the lawyer knows or reasonably should know that the interests of such a person are or have a reasonable possibility of being in conflict with the interests of the client. And for the law students in the room, always go to the comments. Things start to make a lot more sense down there, at least in my opinion. So comment 2, the rule doesn't prohibit transaction or settling a case with an unrepresented person. As long as the lawyer explained she represents the adverse party, the lawyer may inform the person of terms of the agreement, prepare documents that require that person's signature, and explain in the lawyer's own view what terms mean and or underlying legal obligations are in that agreement. So who wants to pull it all together here? What should the attorney in this case, in this hypo, be thinking about? Former boss.
The attorney needs to make sure that it's clear to the downstream irrigator that
he or she, I can't remember, doesn't represent them. And as long as that is made clear, then they can make representations about what the document means, other documents that might need to be signed.
Great, thank you.
Did I pass?
You passed. So, you know, a little kind of a practice checklist. Identify your client, correct those misunderstandings. Don't give legal advice if you know or reasonably should know the interests are in conflict. You can recommend that they hire their own attorney. And in fact, if you're negotiating something like the lease in this, you can put some of that in the lease itself and make sure that as the unrepresented person signs this, you've covered in the lease that you've said those things and have done those things.
So, excuse me, where's the line between shall not give legal advice? Where's the line between giving legal advice and explaining the document?
I was going to actually talk about that because I don't know where the line is. And because I think a lot of lawyers in this room have probably been dealing with pro se parties. And you say, well, these are the terms of the agreement. And then the pro se party says to you, what does that mean? And are you going to say, well, I can't explain to you what that means because to do so would give you legal advice. They're not. You want to get the deal done. So it's a very fine line. And you have to be very, very careful. And I would to be really safe, I would tell the pro se party, listen, I can't explain what these terms mean to you. You need to get your own lawyer to explain it to you, but I can't do that. But this is what the document says. It's a minefield.
So is that different than what the comments suggest?
Yes, I believe it is. And you see, that's why I have in my notes here, the comments aren't the black letter rule. The comments are just meant to be guides. In fact, the court came out with, I don't think you were on the court, but maybe you were. The court came out with an opinion, it's called In re Gilbert, had nothing to do with water, had to do with immigration law, that said the comments to the rules are not what the rules you must comply with. I didn't say that correctly, syntax-wise. But the black letter rules are what controls. The comments are just guidance. And this comment, it bothers me a bit. There are other comments too.
Question over here.
I'm just wondering, like, the answer you just gave, it kind of implicates the access to justice again, because the response is, well, I can't hire an attorney. Can't you just explain it a little? I understand you don't represent me, but
Yeah,
so
but
what's
then,
the lawyer to do that?
well, there's another aspect of this besides the rules of professional conduct. And that is, if you start giving advice to somebody, if you start crossing that line, then you actually have an attorney-client relationship with that person. And that subjects you to malpractice, which isn't the rules of professional conduct. But if the client, the new client now that you've been giving advice to, comes back and says, you advised me improperly, I'm going to sue you for malpractice because I asked you what this meant. You gave me legal advice that established an attorney-client relationship, despite the fact you'd said earlier, I'm not your lawyer. So I don't think I answered your question.
Yeah.
Would it make a difference if you said something along the lines of, like, you know, if that exchange had happened, as Michael just said, and then you said, well, you need to understand that I don't represent you, so I represented the interests of my clients, and from my perspective, you know, it's my understanding that this is what the document means, and this is what these terms will require you to do in the future. But, you know, you should not, or you should understand that relying on my advice about what this document means, you're relying on me as I'm representing the other person. I mean, obviously, once you've said that, they're probably just, you know, but I don't know, it seems like that might be a way of addressing that.
I like that better, but what's going to happen a year or two down the road when the person says, he never said that to me, and there's nothing in writing, you know, so it's dangerous territory.
I was just wondering if there's like a form, sort of like a contract-like form that would work similar to that tiny little disclaimer that was at the bottom of the TICS page or something like that, that would essentially serve that function.
I don't know. It's really dependent upon the wording.
Mr. Tosick.
I'll change your hypothetical and give you access to justice. The downstream irrigator is a corporation or a company. Then you can file a motion to re-refer to the water judge, and they have to get counsel.
Thank you, David.
How do you know when the person's unrepresented? Frequently in water court cases, we'll have parties who were represented in the past, had an attorney, and then enter their appearance as an unrepresented party in a subsequent case. Who do you have to deal with?
I think we're going to get to that.
Yeah, a variation of that, it's a good question.
You're tipping my hand. All right, good. All right, here it is. Downstream irrigator wanting further review of the lease contracts with Legal Sword, an online legal review service. Or, I'm sorry, Law Sword. Law Sword's website says it has arranged for you to have a special law firm available to you. This law firm has been screened and is ready to handle your legal needs. The name of the firm and the name of the lawyer are not known to the downstream irrigator, but Law Sword, the website, sends the draft lease back to downstream irrigator with edits. Downstream irrigator sends the edited draft back to attorney, tells attorney that she hired Law Sword, and asks attorney to answer follow-up questions about the lease. Think, pair, share, 30 seconds, go. Thank you. 5 seconds. Stop. All right, who wants to do the share portion? What should you be concerned about as the attorney when this is going down here?
Is the person represented?
Is the person represented? Yeah. And that's the crux of it, right?
Well, what's the follow-up is, what if they are represented, then what's the problem?
Then you can't talk to the downstream irrigator.
Right. Because you don't have the permission of their lawyer.
Anything?
Whether that person's represented by an attorney, so we don't know, or if it's just limited representation, or if it's some other form.
So let's talk about that first. These things, unbundled legal services, aka limited scope representation. So the American Bar Association defined this as the concept of a lawyer agreeing with the client to handle only some parts of the client's legal matter. And Colorado has explicitly allowed these under the rules. 1.2c, a lawyer may limit the scope or objectives or both of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. A lawyer may provide limited representation to pro se parties as permitted by some other rules, and those have to deal with ghostwriting pleadings. All right, so we have to go to the definition section. What is informed consent? It denotes the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks of and reasonable available alternatives to the proposed course of conduct. And so if you bump down into 1.2's comments, we know scope may be limited by agreement, and it may exclude specific means that might otherwise be used to accomplish the client's objectives. things that the client thinks are too costly, or that the lawyer regards as repugnant or imprudent. Which I thought was interesting. Has any of that ever come up?
I can't say that I ever heard of a case came up where the question was the lawyer regarding something as repugnant or imprudent, but you can reject lots of things if you don't want to on behalf of that your client wants you to do. You don't have to do them.
So moving on to comment 7 under 1.2, those limitations must be reasonable under the circumstances. So for instance, the time allotted for whatever that one piece of this representation is has to be reasonable. You can't guarantee 5 hours for a Supreme Court case or something like that. And that all these agreements must accord with all of the other rules of professional conduct. So this is all from the side of the inner workings of LawSword, right? This is how is LawSword providing representation to the downstream irrigator. But it just raises a host of issues, all of which are found in Colorado Formal Opinion 101 about competent representation, fee agreements, and these websites like Avo, LegalZoom, and Rocket Lawyer are getting banged up, at least on the East Coast, it seems, as violating those states' ethical rules. Other things that are raised, the candor to a tribunal. So, what does an attorney who is contracted with a client for a limited scope representation who ghostwrote some pleadings, if the client tells the judge that they're not represented or haven't had any help, does the attorney have an ethical duty to correct that misstatement by the client, even though they're not even, how would they do that if they weren't even present at the hearing? Stuff gets complicated. Advertising, communications, fairness to opposing parties, and Jamie already raised the attorney-client relationship. This comes up when, if you're on a legal forum, for instance, and somebody types in, I have a question about this legal issue. An attorney writes back some thoughts on a website. Have they created an attorney-client privilege at that point? Something to be aware of.
Let me chime in here about the Avo Legal Services and LegalZoom and other of these entities that are trying to put people in touch with lawyers or trying to give some sort of advice without getting charged with practicing law without a license. Colorado, the Bar Association Ethics Committee is looking at this, and it's likely, from what I've seen, because I'm on the subcommittee looking at it, it's likely from what I've seen the Bar Association Ethics Committee may come down against those types of services because the basic problem is the fee sharing between the lawyer and the service. And but that's a major problem from my point of view because the whole point of unbundled legal services is an access to justice issue. It's so that a client can come in and get the document they need to file drafted by the lawyer in compliance with the rules of the court about saying the lawyer drafted it and not have to pay the lawyer to go to court. And that works in a lot of situations. And not just water law areas, and I think it might work in the water law areas pretty well. So, but you also have to understand that the Bar Association Ethics Committee is just a bunch of lawyers, very good lawyers, I must say, of about 80 lawyers roughly, who meet and discuss legal ethics issues, but their opinions are not binding on the Supreme Court. They're just advice to lawyers from lawyers who've done a lot of work in the ethics areas, but they're not binding on the Supreme Court, they're not binding on the Office of Attorney Regulation. So all that said, do I think that the Colorado Bar Association will follow New Jersey, South Carolina, New York, and Pennsylvania about LegalZoom, Rocket Lawyer, and Avo? I think probably they will, which to me is wrong. I really think, from my personal perspective on this, we should move to a model that makes those legal services available through those Avo and LegalZoom to help people get access to justice.
Thanks, Jamie. But really to the heart of the issue for the attorney is Rule 2.4, dealing with persons represented by counsel, or I'm sorry, communications. So 4.2, in representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or a court order. And here we are where I make fun of myself for defining knowingly. To know denotes actual knowledge of the fact in question. A person's knowledge may be inferred from the circumstances. And one of the examples of this is you can't just bury your head in the sand and sort of cover your ears and say, nah, like I didn't overhear something that they said about having an attorney. That knowledge can be inferred.
Yes, yeah. But it goes back to Scott's question. When do you know the other side is represented? If they come in and with a document that's drafted by somebody else, are they represented? Are you going to go into that?
Yeah, a little bit. No, it's perfect. We're doing on time. So some of the elements, communication about the subject of the representation, the knowingly piece, and the knowingly piece in terms of being represented in that matter. And so in the comments, we get a little bit more clarity. This does not forbid communications outside of the matter. It applies even if the person initiates or consents to the communication with the attorney, so that person is the represented person. And the lawyer must immediately terminate communications if they hit the standard under 4.2. They do throw us a bone here a little bit. You know, if you're really just not sure, you can always seek a court order to figure out what the status is of the representation, either because it's unbundled or it's just complicated. Another practice note is the lawyer cannot make a prohibited communication through another person. So let's go back to this.
Wait on, can we talk about that one?
Yeah,
I
Dave.
thought clients could always talk to each other. I've gotten attorneys on the other side that say, don't talk to my client, but I've always felt that a client can always communicate with another client.
That's true. There's no question that clients can always talk to each other. The problem is you can't tell your client, go tell opposing party X, Y, and Z, because then you're doing through your client something you can't do directly to the other side. So that's a fine line too, because your client's going to ask you, well, what could I tell them? What could I go tell this other person on the stream or whatever? And so you're going to tell your client, well, this is what you can tell them. And so it's a fine line. Legal ethics is a minefield. You all are out there, well, I am too now, representing people in front of the attorney regulation. You're tiptoeing around a lot of times. You know that.
Well, you bring the expert up here with you on these things. So put yourself in the shoes of the attorney. What should you do here? How do you approach this?
The attorney for law sword you're talking about?
Yes, I'm sorry. No, the attorney for the developer. Thank you for the clarification. I know many of your names, so I'm not afraid to pick on people. Yeah.
So, usually what happens in these situations is the attorney for the developer actually, sorry, is this better? No.
Looks good.
Be loud. The attorney for the developer usually just sends a letter or a phone call to Law Sword, and they'll tell them whether or not the person's represented, and that's usually the best way around this problem. Not that I didn't work for a company like Law Sword.
That's great advice.
Have you done that? I mean,
Yeah, I worked for a company very similar for 2.5 years.
and so then they respond to that question.
Absolutely.
That's good. That's
right
great.
away.
Yeah.
In writing, usually.
Yeah.
for Norman, we do not represent this person.
Let's just keep moving. Some further facts. So the downstream irrigator emails the attorney to say she still wants to communicate about the lease. What does the attorney have to do here? Let's say, in this case, the attorney knows that that person is represented. Jason Turner's shaking no. Yeah, the attorney can't talk to the downstream irrigator in that case.
Yeah, because they have to get the permission of the attorney, the attorney for the other side. This comes up a lot for young lawyers who go into practice for district attorney's offices. When you're in court, the defendant may approach you and say, "Can I talk to you about the deal you offered me?" And the deputy DA says, well, "No, I have to talk to your lawyer." And then the next issue that comes up is, well, the defendant says to the young deputy DA, "Well, I fired my lawyer." And then we get into the next issue.
Right. So 2 issues from now. First one, can the developer just send over the lease? Or, I'm sorry, can the attorney direct the developer to just send over the lease? Yeah, we kind of covered that one, right? That is directing somebody to do something that you yourself couldn't do. But here's sort of a stickier question for you. The downstream irrigator confirms with LawSword that she is no longer represented and tells the attorney she is no longer represented. And so my question to Jamie was, is there a difference between a represented person telling a lawyer that they're no longer represented and are in fact not represented versus a represented person authorizing themselves communication with an attorney?
I don't think there's a difference, and I think the lawyer is safest to not talk to the represented person. If you know that a person has been represented by an attorney, and they come to you, like the example I gave of the young deputy DA, and they say, "I've fired my attorney, I'm no longer represented by them," you at that point, you have to check with the lawyer. Just like the young woman up here had said, you have to check with the lawyer to make sure the attorney-client relationship has been terminated. That's the safest thing to do. Will that happen in every circumstance? Probably not. But
Doesn't that have to be, though, by a motion filed and a notice to the clients to withdraw as the attorney for that represented client?
if they've entered if they've entered an appearance, yeah. If there's an entry of appearance in a court case, then until the court has ordered the withdrawal, beautiful, that's perfect. Then you can't talk to the person, period. Even if they're completely at odds with each other, and you know that, they hate each other, and the client hasn't paid the lawyer for a year, you still can't talk to the client.
Jamie, the standard is knowing, right?
Yeah.
And so if 4.2 is triggered by knowing because the client told you they're represented, can't it be untriggered by the client telling you that no, they're not represented?
Maybe. I wouldn't take the risk. I guess it comes down to a question of risk, and to keep my law license, I just wouldn't take the risk. Now, I should be very careful here to say that, to threaten you with your loss of your law license if you violated that rule. That's never going to happen in this situation. It would be much less severe than that, much, much less. Maybe even diverted out of the discipline system altogether, or maybe even dismissed. So I shouldn't have said, you're putting your law license at issue. You shouldn't do it.
So, as
Jonna, it's weird.
Jonna
Yeah.
suggested, maybe trying to contact the entity to figure out is the best way forward.
Yeah.
Can I tell a short story from
Yes,
the
please.
New Mexico perspective? And even though technically the issue did not arise as an ethical issue, it was a bill in the legislature to add criminal penalties to a statement in the statute that said it was unlawful to engage in the unauthorized practice of law. And so this gets more to what you were talking about with LegalZoom and access to justice issues. And what was interesting about that is it put us in the legal services community at odds with our own state bar association, because it was the state bars that was promoting the bill. From their perspective, they were promoting the bill as a consumer protection thing, that if people are paying for services that, and there was, in this case, for services where there was no attorney with law sword, they were non-attorneys. And we have in New Mexico, it's a poor state, we have, landlord-tenant hotlines and immigration, not immigration things, but like how immigrants can protect themselves in various ways in the workplace and that kind of thing. And a lot of that is done by non-attorneys. You might say that's unauthorized practice of law, that's not legal. But the question was, should the penalties be increased and it made to be criminal? And where we were able to get the state bar to kind of back off, or at least not be perturbed by our opposition to it, is they weren't as concerned about the free legal services. They were more concerned with people who were taking money from people and not being licensed. And you might say, well, what's the difference from the person who gets the advice's point of view if the advice is bad? If it's not an attorney, they don't really have a remedy in terms of malpractice or anything like that. But we were able to get the State Bar Association to back off on just making it worse criminal penalties in the statute for unauthorized practice of law until they could come forward and make the distinction in the bill, which they never came back and did, between taking money and not taking money.
Thank you for sharing that. Any other thoughts? Yes, sir.
What if the clients are government agencies? Can you speak with the head of the agency, or do you have to go through the solicitor?
It's like you guys are doing.
Mind reading.
We were going to talk about that next. So the next panel is supposed to go on it for. Should we save those 4 minutes for transition?
No, it's okay.
I mean,
You're done.
I think we're at a natural stopping point. What we were going to say in terms of, so governments have special rules in terms, all citizens have a right to address their government. So there's a constitutional right. And there's good information in another formal opinion that talks about, so if you're dealing with a city, trying to do maybe a water deal with the city, the city has a city's attorney's office, but is the city staffer that you're talking to, are they actually represented in that matter by the city attorney's office? That's a question. Another question is, who is sort of in the level of government are you talking to? Are you talking to somebody on the bottom who doesn't supervise or direct or have the power to legally obligate the city in a deal? Or are you talking to somebody much higher up who actually has sort of daily conversations with the city's attorney's office and can direct the city attorney in that way? And so you kind of perform a case-by-case analysis depending on who you're actually talking to at the government.
Yeah, that the comment to Rule 4.2 is pretty good about this, by giving guidance on who you can talk to and who you can't. But it gives you have to then make the decision. Well, is this person in a control group type of person? Is this person actually represented in a matter by the city attorney or the attorney for the agency? And also, if it's an adjudicative dispute. I mean, if there's a board that's making a judgment about something, then the lawyer cannot ever directly communicate with that adjudicative board, even though they may on other things. But if they're making an adjudication, that would be like communicating directly with a judge in a case, and you just can't do that. Well, you know that.
We'll cut ourselves off now. Thank you very much.